Enoy Extreme Media UJ. Subscribe for all updates.
Interested in a stay of these proceedings because there are two reasons. There are a number of reasons, but one of them is that under Section 17 of the Kata Act, this honorable court is subject to the supervision of the High Court. And under subsection 2 of section 17, paragraph C, the High Court has to ensure that the substantive justice is done, just like we are enjoined by Article 126(2) of the Constitution. That cannot happen, Your Honor, if you continue with the proceedings that the Constitution wants to bring today without giving High Court a chance to look at the record of today and entertain our technical and legal objection to the way that this court has, although it is obliged, calculated the remand period, refused. That's one of the issues which are being taken there. So one of the questions for High Court is a magistrate empowered to decline to calculate remand days from 20th November last year to date? Is the magistrate legally, in law, not in caprice, is a magistrate in law, not caprice, entitled to decline to calculate, to count mathematically the days that an accused person or accused person has spent on remand? Our opinion is that is plainly unconstitutional of that magistrate. We want the High Court to intervene, and it cannot intervene unless this court allows it. Because the point of mandatory bail, you would like it beyond record? Your Honor, the point of mandatory bail is to ensure the personal liberty of the accused. It is not something made perfectly. It is made so that life and meaning is given to the presumption of innocence, among other reasons. So this is a matter concerning fundamental human rights and freedoms of the accused person. So in making this application, pursuant to the provisions my colleague alluded to and Section 17 of the Kata Act and the other provisions, is that we are trying to go to High Court to cry out to the High Court and say that the person the bail guidance told to calculate days has refused and has said so in writing that I have not counted the days. What is stopping her? The state will explain. Why is she refusing to count the days of remand? Yet the law does not even give her the option not to. Those are some of the questions we'll be taking. Thank you very much.
In reply to the application, the defense is seeking this court, one, to stop the proceedings before it. Two, refer the matter to High Court for revision. Because they want the High Court to find out whether the proceedings are in line with the procedure defense cited a matter which is before your land calling chief magistrate. For whom the allegedly said stopped the proceedings and referred the matter to High Court for revision. What is the law on revision? That is where we should be beginning from. Revision is provided under Section 48 of the Criminal Procedure Code Act. Cap 122. Laws of Uganda. Revision is a preserve of the High Court. And the procedure is that the defense make an application in the High Court. They make the application in the High Court. And then High Court, if deems it necessary or fit, calls for the record from the lower court. It is not anywhere in the law under section 48 and 50 of the Criminal Procedure Code Act that it is provided that the magistrate or the lower court who is in personal conduct of the matter under dispute is by law supposed to A, stop the proceedings, refer the matter, and send the record of proceedings to the High Court. It is not anywhere. The defense are using a completely different procedure altogether. It is the High Court instead which is supposed to call this record if it deems it necessary. And this court is, you should be not obliged at any point to stop the proceedings in this matter, because there is nothing wrong on the record. And by the way, there is no provision that defense has to lay out the reasons as to why they are seeking a revision. Whether you have 100 reasons, that is your own. You can only do that when you're seeking a constitutional reference, not in a revision. So the procedure they adopted is completely, I don't want to say unlawful, but it is irregular. It is misplaced, for want of a better word, for lack of a better word. The defense submitted that your colleague, when faced with such an application, stopped the proceedings and did the rest. Whatever she did is not binding on this honorable body. Whatever the person, I don't know, whatever magistrate, I do not know, because I was not part of that proceeding. Whatever happens there does not bind this court. In any case, it was irregular, because it was supposed to be High Court to do that. Merely the fact that someone did something in a manner is not, in a particular way, is not a prerequisite for another person to do it in the same way, especially when you're at the same level. So it is not persuasive in any way, and it's not binding, because there's no authority to that effect. Prosecution has been on record, and I will insist. Yes, Your Worship, they have been getting a lot of time. Prosecution has been on record, and we shall insist that this is one of the ways of ensuring that this matter is never had. That is not to say that we are pro or we are against the rights of the accused persons, but there is a path this matter is taking that every time prosecution wants to do something, they are arm twisted. And then we go to another thing. I don't know the purpose of that, but I can see this application is in bad faith. It is in bad faith because they are not supposed to inform you. They should go to the High Court. They should be just informed by High Court letter calling for this record. It is a waste of time, and it is my submission that you dismiss it and you proceed, because our committee papers are ready. We don't want people to lament and say prosecution, the people in custody, they are not committed. We are ready to proceed in this matter.
Serious matters. First of all, I think my brother misunderstood the scope of our application. It's not just a revision application. This is also an application for supervision. And as I ever said, but he failed to hear, it is also premised on Section 17 of the Judicature Act. Your Honor, logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings by the prayers of the prosecution. In other words, you will be indirectly telling us that we don't go to High Court, because there will be no purpose of going to High Court if you are going to hear committal proceedings. It is both illogical but also illegally unconscionable to entertain committal proceedings whose net effect is to frustrate the mandatory bail of accused persons. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this pre-trial proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in a military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed? Please.
What can I just?
Yes, I'm not raising issues. So Article 43 of the Constitution, and in the context that I've said, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail, is a stellar example of political persecution, which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion. You are not going to zip my mouth.
Just a minute, Your Worship.
That's okay, sir. Let him also.
You see, Counsel, I don't want to take you back to fairness. Because this is what we call, we need to proceed in a manner that actually represents what we hold up. If you hold up as a lawyer, then present your facts and evidence as a lawyer. You cannot submit in this court and attack the office of the DPP that they are coming up. Yes, what do you record? And you say that the office of the DPP prepared the committal papers in a bid to deny the applicant from benefiting from mandatory bail. Did we have an agreement with you? We are performing our role as DPP. So there are some things, yes, there are some things that shouldn't be said here. Otherwise they become too unprofessional and courteous.
Yes, I'm finishing. Subsection 5, clause 5 of Article 120 on the power on the Office of the Director of Public Prosecution reads as follows: that in exercising his or her powers under this article, the Director of Public Prosecution shall have regard to public interest of the administration of justice, and the need to prevent the abuse of the legal process. What are we seeing here, Your Worship? A classic example of the abuse of the legal process by the Office of the Director of Public Prosecution, in his words, claiming that they have come with the committal papers so as, in my opinion and the opinion shared by the entire legal team and the accused persons here, to frustrate mandatory bail. We implore this honorable court to prevent that abuse of legal process, because it is also tantamount to political persecution prohibited in absolute terms by Article 43 of the Constitution. We cannot run away from the context of this matter. Thank you.
Just for a few minutes, then I come back again.
Abalungi abatuuliriza era abatulaba olunaku olwaleero tuchaddeko ewa Sheikh Asiraf Dembe.
Sebo sanyise okubalaba amannya agange Seeka Asiraf Dembe akola ku bizibu by'enjawulo. Omuntu singa aba alina ebirwadde musomereddwa tumuwa amazzi ga lukuya nga bw'obadde ogalaba, tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa. Abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa, ne waba atatuuse nga mpadde amannya ge naye ng'ali wala. Neetaase enamba yange yeeno eri 0701763711. Nammwe bannyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku dduwa ng'olina ebizibu, viza zibuze, amaka gakolongotana, sente zikola zimpita mu ngalo, ojja kumpeereza ekifaananyi kyo n'amannya go, ebyo byokka bijja kummala. Nja kukulombera edduwa, ojja kutereera. Olunaku olusembayo mu mwezi mba n'edduwa ey'awamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.